Welcome to Chapter 12 on Consideration. The law does not hold us accountable for every promise we make. The doctrine of consideration determines which promises a court must enforce. Promises are the uniquely human way of ordering the future. Consideration does not require counteroffers. You may equate bargained for with haggled over. A simple example can demonstrate the meaning of bargained for in this context. Kurt offers to mow Pedro's lawn once a week for $50 beginning May 1st and ending November 1st. Pedro accepts the offer. Where is the bargained for exchange? Kurt promised to mow Pedro's lawn to induce Pedro to promise in return to pay Kurt $50 a week. Pedro responded to Kurt's inducement by promising to pay Kurt $50 a week if Kurt mows Pedro's lawn. Consideration means that there must be a bargaining that leads to an exchange between the parties. Consideration can be anything that someone might want to bargain for. A promisor is the person who makes the promise, and the promisee is the person whom the promise is made. Bargaining is obligating yourself in order to induce the other side to agree. The thing bargained for can be another promise or action, a benefit to the promisor or a detriment to the promisee, or a promise to do something or a promise to refrain from doing something. In the case of Kelso versus International Wood Products, Carol Kelso worked at International Wood, and her supervisor, Rene Hernandez, promised Kelso 5% of the company's stock, but he never gave it to her, and she sued. The trial court gave a directed verdict for International Wood, and Kelso appealed. Is Hernandez's promise binding? The holding was that the promise is not binding and International Wood wins. The promise to issue the stock was gratuitous and prompted only by Kelso's past job performance. The promise was without consideration and created no binding contract. At trial, International Wood's lawyer got Kelso to admit that she had never promised to stay on forever or to stay on for 5 years in return for the promise of stock. Why did the trial lawyer prompt her this way and ask her questions like this? If Kelso had made such a promise, there would have been a valid consideration on both sides, and Kelso could enforce the company's promise. The lawyer was trying to demonstrate that Kelso gave no consideration and thus could not enforce International Wood's promise. Didn't the company's lawyer take a great risk in asking about what Kelso had promised? If she had said, I promised to stay for 5 years, and in return they promised me the stock, wouldn't that have been fatal to the defendant's case? There was no real risk because the lawyer had presumably asked the same question during a deposition. To ask the question for the first time during trial would be terrible legal work, but this lawyer knew exactly the answer he was going to get. Courts seldom inquire into the adequacy of consideration. A previously paid benefit is generally not consideration because it was not meant to induce the other side to agree. The exception is economic benefit. In some cases, courts will enforce consideration that is an economic benefit given with the expectation of later payment. In an illusory promise, if one party's promise is conditional, the other party is not bound to the agreement. In sales law, Section 2-306 of the UCC expressly allows output and requirements contracts in the sale of goods. A promise to do something that the promiser is already obligated to do is not consideration. The exception to this is additional work. When a promiser agrees to do something above and beyond what he is obligated to do, the promise is generally valid consideration. Another exception is modification. If both parties agree to a modification, the best solution is to rescind the contract and draft a new one. Many people believe that each party to a contract must receive economic benefit from it. It's not an unreasonable belief. Value, however, is not limited to economic benefit given from A to B. Hamer v. Sidway provides engaging facts and illustrates modern contract law's broad interpretation of value. In Hamer v. Sidway, William Story wanted his nephew to grow up healthy and prosperous. In 1869, he promised the 15-year-old boy $5,000 if the lad would refrain from drinking liquor, using tobacco, swearing, and playing cards or billiards for money until his 21st birthday. The nephew had a legal right to do those things. The nephew agreed and kept his word. When he reached his 21st birthday, the nephew notified his uncle that he had honored the agreement. The uncle congratulated the young man and promised to give him the money, but said he would wait a few more years before handing over the cash, until the nephew was more mature. The uncle died and his estate refused to pay. Hamer, to whom the nephew had transferred his rights, sued. The estate argued that the nephew had given no consideration for the uncle's promise. The trial court found for the plaintiff, and the uncle's estate appealed. Do you think did the nephew give consideration for the uncle's promise? The judgment for plaintiff affirmed. The nephew gave valid consideration by refraining from doing the things he was legally entitled to do. The estate argued that there was no consideration because the nephew benefited from avoiding the prescribed actions, but the court was unpersuaded. Courts will not ask whether the thing which forms the consideration does in fact benefit the promisee or a third party, or is of any substantial value to anyone. It is enough that something is promised, done, forborne, or suffered by the party to whom the promise is made as consideration for the promise made to him. The nephew transferred to Hamer his right to receive payment from the uncle. The uncle's estate claimed they denied payment to Hamer because the nephew gave nothing to the uncle in exchange for the uncle's promise. Therefore, there was no consideration and no contract. The estate characterized this transaction as a promise to make a gift, not enforceable as a contract. So then, what was Hamer's argument? Hamer argued that the nephew did give something to the uncle in exchange for the uncle's promise. The nephew's promise to refrain from alcohol, tobacco, swearing, and cards until he turned 21. The uncle received no benefit from the nephew's promise. So why does the court hold that the nephew gave consideration? Because the nephew promised to suffer a detriment. But the nephew gave up activities that were bad for his health. So you may be wondering, what detriment did he suffer? Detriment here does not mean that the nephew experienced adverse consequences. One suffers a detriment for purposes of consideration by promising to refrain from something one has a legal right to do, or promising to do something one is not obligated to do. A liquidated debt is one in which there's no dispute about the amount owed. In cases of liquidated debt, if the creditor agrees to take less than the full amount as payment, her agreement is not binding. If the debtor offers a different performance to settle the debt and the creditor agrees, then the agreement is binding. A debt is unliquidated if the parties dispute whether any money is owed, or the parties agree that some money is owed but dispute how much. The parties may agree to settle for less than what is owed. This accord and satisfaction will be enforced if the debtor pays the agreed amount. Common law ruling states that if a debtor writes full settlement on a check and the creditor cashes it, the payment is in full whether or not it was the right amount. UCC 3-311 affirms the common law ruling but adds two exceptions. Organizations may notify debtors that any offers to settle debt for less than the whole amount must be directed to a certain person, and the creditor can refund the payment amount within 90 days and then demand the full amount. In the case of Jones versus Allstate Insurance Company, Jeremy France caused an automobile accident that severely injured Janet Jones. Allstate Insurance represented France and his parents, who owned the car he was driving when he caused the accident. Klein, who was an Allstate agent, helped Jones and her husband by identifying Janet's medical coverage, prodding insurance to pay medical bills, and obtaining $30,000 in underinsured driver's insurance from the Joneses' own insurance company. The Joneses considered Klein more helpful than their own insurance company agent. Klein sent Jones a letter, a $25,000 check, and a form releasing Allstate and the Frances from liability. The check contained this type notation: final settlement of any kind and all claims arising from bodily injury caused by the collision with Jeremy France. The Joneses did not sign the form. They deposited the check, but 9 months later had second thoughts about it and sent Allstate their own check in the amount of $25,000. Allstate returned the check, saying the claim was settled and closed. The Joneses sued the France family and Allstate. Allstate claimed an accord and satisfaction, but the trial court ruled against the company. The Frances and Allstate appealed, and the case reached the Washington Supreme Court. Did the parties enter into an accord and satisfaction? Judgment for Jones was affirmed in the holding. The Allstate check was not tendered in good faith as required by the UCC. Evidence indicated that full satisfaction language routinely appeared on Allstate settlement checks. A comment to the relevant section of the UCC provides as an example of lack of good faith the routine printing of full satisfaction language on business checks. The Allstate check the Joneses received was computer-generated to bear the full satisfaction language and fall squarely within the example of lack of good faith provided by the UCC commentary. Because the transaction did not meet the good faith requirement, Allstate did not assert the affirmative defense of accord and satisfaction. So what is an accord and satisfaction? An accord and satisfaction is an agreement in which parties to an unliquidated debt agree that the creditor will accept less than the amount of her full claim as full payment to settle the debt, followed by the debtor's payment of that amount. What is an unliquidated debt? An unliquidated debt is one in which the parties either dispute whether money is owed or agree that some money is owed but dispute the amount. What is a release? A release is a contract by which one person agrees to the release, i.e. not to sue for legal claims against another in exchange for payment or money or other consideration. What was the unliquidated debt in this case? It was the amount due from Allstate to the Joneses to compensate for Janet Jones's injury at the hands of France, Allstate's insured. How much did Allstate think that it owed the Joneses? They thought they owed only $25,000. How much did the Joneses think that Allstate owed them? More than $25,000. How does an accord and satisfaction raise issues of consideration? An accord and satisfaction involves the modification of an amount to which the debtor believes he's entitled. How did Allstate attempt to create an accord and satisfaction? By printing that $25,000 check it sent to the Joneses that it was paid in final settlement and all claims arising from the accident. Why did the court rule Allstate did not create an accord and satisfaction? Because the UCC requires the debtor to offer an accord and satisfaction in good faith in order for it to be binding. Why did the court rule Allstate did not offer this accord and satisfaction in good faith? Because Allstate routinely prints the final settlement language on computer-generated checks. The evidence didn't show that Klein or anyone else at Allstate intended this to be an accord and satisfaction. Why wasn't it in good faith? Unfortunately for Allstate, a commentary to the relevant section of the UCC uses routine printing of full satisfaction language on business checks as a prima facie example of a lack of good faith. The law does not hold us accountable for every promise we make. The doctrine of consideration determines which promises a court must enforce. Congratulations, you completed Chapter 12 on consideration.